City's been doing a substantial amount of these affidavits. They're highly, highly effective. They're on point. They're very understandable. They're very simple. They're very concise. So they're hitting us hard. They're coming back. Now, those of you that I've already discussed with, when I ask this question, shut the hell up. You have the answer. They are coming back and they're trashing Cindy. They're saying that our people belong to some group that's charging money to teach this. Now, we have affidavits, and y'all may get dragged into court at one point or another when they try and execute me to say, "Ooh, we don't pay them. We give them some money as a donation, but it has nothing to do. Nobody gets paid here. It's not about, it has anything to do with money." Because then there would be some liability issues under the law. So everybody completely agrees you donate what you want to do and nobody's charged you at all. Right?
That's true. That's
right.
Okay, yeah, guys, the phone don't pick up the head nod.
Absolutely right. True. Yeah.
Okay. So they're trying to claim that so that they can somehow shut us down eventually by saying it's a for-profit business. There's no profit, there's no money. There's donations, but they don't have anything to do with this. So they're coming after the group and Cindy to impeach our character. Why?
Because they can't answer.
They can't impeach the documents.
There you go. This is just very typical in law. When the opposing counsel can't impeach your evidence, what are they going to do?
Kill the messenger.
Yes. And when they try and kill the messenger, what are they admitting?
Guilt.
They can't impeach the documents. If they could impeach anything in our documents, they wouldn't even bother talking about us. They would want us to continue on. They would want us to keep teaching stupid stuff. They would be all for us. Hell, they'd be sending us donations to grow. Just like in the show me the note theory. The reason that grew so big, I think, is because the other side wanted it to get big. Just like in this other person's case that spends all her time talking instead of listening. See, God gave you 2 ears and 1 mouth. Do the friggin' math, guys. There's a reason he did that. And no, I don't know why vocal cords work before you finish puberty. I have no idea where that concept came in.
I have a question. You say that nobody pays for anything, but if I do a affidavit for somebody,
that's
a
a
work
business.
for hire.
That's
That's
a work for hire thing. That has nothing to do with the group.
Right. I just wanted to clarify.
Charles Horner has nothing to do with the group.
Right.
There's all kinds. McCaffrey has nothing to do with the group. What you guys do in your business life, if somebody here paints somebody else's house, that has nothing to do with this group. Nothing. We use your services. We use Horner's. We use McCaffrey's. There's other people that have businesses. There just are. There's paralegals that write pleadings. So, but that has nothing to do with the group.
Right.
So I'm not worried about that aspect of it. This person that always talks, in her case, the attorneys went real hard on the whole note concept. Why does that not matter?
It's not about the note. It's about the loan.
What document garners the rights to do a foreclosure?
Do you trust?
That's why they want to talk about the note. Nobody wants to talk about the deed of trust. So if they say they don't have to show the note, okay, I don't care. I gave you the note, you gave me the house, that deal's done. They don't want us talking about the deed of trust. That's where they get the rights to foreclose. That deed of trust is no good, they don't have the right to foreclose. They know this, they're not idiots. So they get us talking about the wrong thing, and that's what happened to that person. Well, when we're doing all of this, and you supposedly learn this stuff, you need an expert's opinion to quantify and qualify that your opinion is correct. But you should also do your own affidavit. Do you understand that?
Yes.
Okay. How does somebody rebut an affidavit?
With an
With affidavit.
With an affidavit.
Or oral testimony.
Under penalty of perjury, not just oral testimony.
Right.
Okay, the attorney can't just stand there and bitch.
Right.
Which is primarily what they do, but then you shut him down for hearsay and say, Judge, will he say that under penalty of perjury and under oath? Because if he don't, you need to shut the hell up right now.
That's exactly what happened in this.
So, when you do the affidavits, the fact that they're not going to rebut the affidavits under penalty of perjury, sworn in under oath, or an affidavit form, what is the only thing they can bitch about? Whoever did the affidavit.
Credibility. Credibility of the individual.
Yes. Is that allowed to stand?
No.
Yes, it is.
Yes.
If you don't object to it, sure it is. Acquiescence applies in court. If you don't object, then that stands. So when they rebut all of this stuff, then you have to put in your pleading that, you know, they need to shut up. They need to go under oath, under penalty of perjury, and if it's a pleading in affidavit format, or they just need to shut up. Now, John's case, Haskins' case, somebody else's case, the attorneys just hit hard. They don't even talk about the evidence. They just start cutting down Cindy and the group. What does that tell you, guys?
Trying to make her incredible.
We're right and they're wrong.
No, it tells you we're completely right.
Yeah.
What?
Tell them what they cut me down on, that I'm involved in a case suing my own banks.
Oh, yeah. Yeah, and it's, you know, what does that have to do with anything? But the point is, when you can cut down the evidence, you do. They flat out won't do it. What does that tell you? If they're not even attempting to cut down what we're saying legally and with our evidence, what does that tell you?
Again.
You're absolutely right.
We're 100% right. That's it. They're not even arguing the facts. They won't. Because if they argue the facts, they'll have to go under penalty of perjury and say the same thing, and then they're screwed. Yeah.
Net resources. They're desperate.
Yes. And that's exactly it. If you've ever been involved in like a rape case or a child molestation case, you see the defense attorneys will be attacking the victim. I mean, I've heard in molestation cases the defense say that the young person seduced the older person. That's how bizarre this shit can get. Because you can't impeach the evidence. When you do that, you go after people. Well, in civil, that's prima facie evidence. They can't impeach the evidence. So you've got to object. In other words, if they rebut it by impeaching your character or the witness or the affiant's character, if you don't rebut it, that stands. Do you understand that?
Yes.
Okay. So everything that they say you must object to and you must rebut. Because they didn't do it in affidavit format, then it's just hearsay and you rebut it on that. And you can rebut what they say without doing it under penalty of perjury, under oath, affidavit format. But if you do it, if you put in an affidavit rebutting their stuff, they're screwed. Do we understand that?
Yes.
So everything from now on, do it under in affidavit format. Guys, we're real close. We have half a dozen cases right now with the affidavits and sworn testimony on our concept of why the whole thing's fraud. They haven't fought any of it. They're still coming back and saying this is a vapor money theory, this is a show me the note theory. We don't even bring up the note.
Where'd vapor money come from? I never even heard
Okay,
of that concept.
vapor money theory is the concept, the whole Patriot thing of, all right, there's a few ways you can tell that the Patriots are friggin' whacked. First of all, they say there is no legal money in the U.S. Yes, there is. You can read it in Black's Law Dictionary, legal money. Anytime I hear a Patriot scream, there is no legal money, I know you're friggin' whacked, or you have no idea what you're talking about. Now, is there money? There's really not money. Is there legal money? Absolutely. You understand there's a big difference between legal and real? One has nothing to do with the other. Nothing. Legal is just fiction based on decisions. Yes.
So basically what you're saying is that little thing printed on our quote Federal Reserve notes, this note is legal for all debts, public and private?
Sure.
Basically what you're saying?
Well, that makes it legal money.
Yeah, okay.
Pursuant to the Black's Law definition that the United States government has accepted Federal Reserve notes as the currency for this country. Therefore, it's legal and lawful money. Now, is it truly money? Not even by any stretch of the imagination. But we're talking law, we're not talking reality. So, when you see those aspects in pleadings, judges get nuts because they go, just a second, because it goes towards the vapor money concept. The vapor money concept is relying on a couple of aspects. I don't know that there's been a ruling or a decision or an adjudication on the concept, but there's only a couple elements. Vapor money is intrinsically tied to the concept that the bank's lending credit instead of assets. And we use that argument, it's true. Banks cannot lend credit, but how do you prove that they're lending credit? Then some people bring in the whole, there is no lawful money, so that one gets thrown out. That's the quickest way to kill a court case. The concept that the banks are lending, we all know where the only loan is, right? Where is the loan in this? We say, show me the loan. Where is the loan?
Promissory note.
No.
The deed of trust.
Deed of trust.
No. Okay, go ahead, because they all got it wrong.
The only loan involved is the loan the bank gets when they use your promissory note as collateral to borrow from the Federal Home Loan Bank Board.
See, that's why I'm saying show me the loan. That's why I came up with it. Show me the friggin' loan. Because I know where the loan is. The loan is where I gave you my note, you gave me the house, we're done. Then you took my note over to that federal bank, you used it to borrow money, and then you lent the money to me. But I never got the money, you kept it. Show me the loan. Well, if they ever show you the loan, it's going to be 3 steps down the road and it had nothing to do with you. So, that's the vapor money theory, is that you never, that the bank did give you money, but they accessed that money through a loan. And banks can't lend credit, they can only lend something based on their assets. And it won't work. That won't work. But we don't use that argument. We don't. There is a loan, it's way over there, show it to me. Has nothing to do with me, we never got the loan. So, they're misdirecting. Remember, they get us to look at the pretty girl instead of the magician.
One of our arguments is we never got the loan pursuant to the deed of trust. I would like the loan and the parts of the deed of trust that are lawful. Give me the loan, I'll take it, and I'll make the payment.
Sure. Yeah, that's the whole concept is show me the loan.